All right, good morning, everyone. I am Jay Hall, the Deputy Director and General Counsel for the Kansas Association of Counties. And today we are going to talk about the Kansas Open Records Act. If you were with us last week, you heard me talk about the Kansas Open Meetings Act. And today we're going to talk about open records. So what we're going to talk about today is obviously what is a record. We're going to talk about some of the exceptions to disclosure. We're going to cover the anatomy of an open records request. And then as always, I'm going to talk about some best practices. As I said last week, if you were with us, you heard me talk about open meetings, and that is one half of the transparency duo. The other half, obviously, is the Kansas Open Records Act. Open records and open meetings they kind of work together to make sure that our electorate is informed, that the citizens and residents in your respective counties are aware of what's going on and also have access to the information that they need in order to know what's going on within their communities, because that's really why the open meetings and the Open Records Act exist. So let's jump right in and start talking about what exactly is a record. Well, the statutory definition says a record is any recorded information. So anything that is recorded, and that's regardless of the form, the characteristic, or the location that is made, maintained, or kept by, or in the possession of a public agency. So let's think about that. That's any recorded information. Any recorded information can mean emails, voicemails, written letters, documents, forms that a department or an entity may hold, videos, audio recordings, voice recordings, any sort of thing like that. So any recorded information. I mean, it goes the entire spectrum. So if 20 or 30 years from now, we have a different type of recorded information, if, for example, in 20 or 30 years, we're leaving holographic messages instead of just regular video messages, we're leaving holographic video images as messages, that would be an open record at that time. So it's any recorded information, whether the technology exists now or that technology is developed in the future, it would be any recorded information would constitute a record if it is made, maintained, or kept by a public agency. Now, obviously, there are exceptions to the Open Records Act, and I want to touch on some of those exceptions. Some of those I'll touch on specifically, some of them I'll just kind of gloss over because obviously we don't have time here in the next hour to do a deep dive on every single exception. That's just not possible. There are a lot of exceptions, and it could take the entire hour just to talk about some of the exceptions. But I want to make a note before we get into the exceptions that the burden for proving that the exception applies in a specific case is on the agency. And in the Open Records Act, when it says agency, that just means the public agency. So the county, for the purposes of the Open Records Act, is considered an agency. So it's important to remember that if you are going to use an exception, the burden for proving that is on the agency, is on you as the county to prove that record falls under the exception and therefore does not need to be disclosed. Now, one of the things that I like to talk about when I talk about exceptions to the Open Records Act is there are four broad sort of broad categories of exceptions. And these don't cover all of the exceptions, but they cover most of the exceptions, and they cover all of the exceptions that we use on a more regular basis. And the first of those that I always start with is the legal or courtroom exceptions. And those include records that are privileged under the rules of evidence, criminal investigations, civil litigation, and then attorney work product. All of those would not be subject to disclosure under the Open Records Act. And the reasons behind that are fairly obvious, honestly. It obviously if a record is privileged, you wouldn't want to be turning that over because it's privileged. And if you were to turn that over, then that destroys the privilege. Likewise, with criminal investigations or litigation or records pertaining to litigation, there are certain rules that govern how those are turned over in criminal and civil matters. And so we would follow those rules rather than use that use the Open Records Act as an avenue to have that information turned over. And then attorney work product. Again, pretty self-explanatory. If an attorney is developing that information under work product, that would fall under the rules of civil procedure and not under the rules of the Kansas Open Records Act, and therefore would not need to be turned over under the Kansas Open Records Act. But as I stated before, all of those, if you were to use any of these exceptions, and not just these exceptions, but any exception under the Kansas Open Records Act, the burden for showing that that exception applies in this particular case is on the county to demonstrate that that exception applies in this particular situation. The next broad category I want to talk about is the medical or patient exception to the Open Records Act. And I've got the citations there for those different exceptions. They all fall under the same paragraph, but it's medical records, psychiatric records, psychological records, and alcoholism or drug dependency treatment records. And obviously, again, these it's fairly clear to understand why these records would be exceptions, because you want to protect the privacy of individual patients. That information about somebody's medical records should not be turned over to the public. And I always, when I talk about these exceptions, I like to mention that in smaller communities, you need to also be aware that when you are, even if you don't identify a specific patient, you need to be somewhat careful, because obviously in smaller communities, it's fairly easy to use deductive reasoning to figure out who a record may be talking about. And so you want to be careful, even when you're in your smaller communities, even if you don't disclose names or things like that. You want to be careful when you're dealing with these types of medical and patient information, because people may be able to figure things out just based on some general information. So always be aware of that and cognizant of that as you're working through that. But again, the burden is on the county in order to prove that these exceptions apply. Next broad group of exceptions that we have, and this is probably one of the larger groups, is the exceptions that apply to individuals. And these are kind of personal privacy types of things, because again, while we have individuals that are obviously in the public light, counties also hold records that are personal and private to individuals. But we have that private information for a variety of reasons. We may have private information that is contained by the county or held by the county, and that information, again, doesn't need to be turned over, but it is the burden of the county to demonstrate that the exception applies to those particular records. And then finally, the last broad group of exceptions is the business exceptions. And again, I call these business exceptions, but they would also apply not just to businesses, but also apply to not-for-profits and other entities, and for the county itself. And basically, the idea behind these exceptions is, again, not wanting to give out business or private entity information prior to when it would be appropriate. And the one I like to highlight here in particular is this first one, the notes, preliminary drafts, or research, because that's important for not only other outside records, but also for county records. So if you are, every county takes minutes for their meetings. Those minutes, while they are in draft form, until they've been approved by the Board of County Commissioners, or if you have a Planning and Zoning Commission or a hospital board, or all of those, any of your entities that takes minutes at their meetings, until those minutes have been approved, they are not subject to the Open Meetings Act because they are a preliminary draft. Once those minutes are approved, however, they do become an open record, and it's important to remember that. You don't have to submit the preliminary draft of those minutes as an open record because there may be changes, there may be errors in there that need to be corrected. And it's not required that you turn over that information until they have been approved and it is no longer in draft form. At that point, that becomes an open record. This is also important because you may be within your county developing policies or procedures or other documents, and you may be sending drafts back and forth between people in your county counselor's office or in various departments in your county. And while those things are working through the drafting process, while those things are working through the process of being developed, again, those are not subject to open records. Only the final document is subject to the Open Records Act. And again, that's because as you are working through that process, things may change. Those preliminary drafts, those are not the official document, those are not the final document, and those are not subject to it. But you want to make sure that once you have that final document, that is subject to the Open Records Act. And so you want to make sure that you're aware of that. And then notes kind of fall under the same type of thing. If you have county commissioners or other county staff that take notes during meetings or things like that, those notes again would not be subject to the Open Meetings or the Open Records Act either. Those notes are just, they may be things that help them jog their memory, but they are not subject to the Open Records Act because they're just notes. All right, so now I want to talk about what your responsibilities are. And it's important as we think about the Open Records Act that we think about the responsibilities that each of us has when dealing with the Open Records Act. And it's important to think about that because, and I say we in this case, because KAC is subject to the Open Records Act and the Open Meetings Act, just as your counties are. And so it's important that we look at our responsibilities collectively for turning over records. And the responsibilities are fairly straightforward, but I want to touch on each of these things. We have basically these 5 responsibilities that I've noted here. Make records available to the public, to any person. And it's important to remember, the Kansas Open Records Act is broad. It is more broad than a lot of other sunshine laws throughout the state. And I say sunshine laws because these are basically the laws that demand that business be conducted in the light so that people can see what's going on. And the Open Records Act requires that records be open for inspection by any person. And we'll get into that, but that means any person, regardless of whether they live in your county, whether they pay taxes in your county, whether they are a resident or a citizen or anything like that. They don't have to have any tie whatsoever to your county. Any person can request records from your county, and the Open Records Act would require that you turn those records over. The Open Records Act also requires that you notify requesters when and where records will be available. It requires that you provide access to those records. It provides that you allow people to make copies of those records or make copies for them. And when applicable, it requires that you provide copies or collect fees when applicable. I have a question here for exceptions related to public safety. And there are exceptions related to public safety. A lot of them fall under the legal aspect, obviously with criminal records and things like that. But there are also exceptions for, and I can't remember if I have them listed, but there are also exceptions for plans, designs, and drawings that are prepared by someone other than the public agency. But there's also an exception for security information. So If you have documents related to courthouse security, for example, those would not be subject to open records either. And again, for kind of obvious reasons, to make sure that you're not turning over your full security plan in a situation where people can then see your security plan and possibly compromise the security of your personnel in that situation. So just be aware of that there are exceptions for that. I don't think I put those exceptions in the slides here, but there are exceptions for that. So let's talk about each of these things. So you're required to make records available. And again, this is you have to make records available to any person that requests it. And fortunately, in this situation, technology is your friend. Records can be made available through technology, which can make it easier and also lower the cost and the time that is spent making those records available. But records have to be made available to the public and to any person. It doesn't matter if this person lives in your county or not, if this person pays taxes or not. Any person, anybody that exists and is able to make a request is authorized to receive those records. And so that's something that's important to remember. We've got another question. What records should we be recording in regards to a potential KORA request for social media? If your county has social media pages, whether that's tweets or a Facebook page or anything like that, you should not be hiding documents and information on your Facebook page or things like that. You should make it available to anybody that is going to be on there, so that anybody that wants to see that page, your page should be public if it is the county's page, to where anybody that is obviously on Facebook or anything can see that. In addition, you should probably be archiving the information that you post on there. So if you post on your Facebook page, for instance, an alert about courthouse hours, for example, if you're going to be closed on a holiday, you should probably also be saving that information somewhere else outside of Facebook, so that you have a record of that, so that anytime you are making an official post, that you have a record of that. Now, there are companies that will archive that information for you, or you can do it yourself. It's really up to you. If you don't want to go into the cost of it, you can archive that information yourself, or you can certainly pay a company to archive that information for you. But you should, at a very minimum, any information that you post on your social media page, you should be prepared to make those posts available to the public. And then the second question is, do we have the right to request information vetting the request when we feel they may be posers or potential safety risks, such as requesting address, full name, etc.? I do recommend that, obviously, if you're getting a request from somebody that you don't know, you should be collecting their name, address, contact information, because you're going to need that information to get that information to them. So you should be collecting that information, if for no other reason than to make sure you can provide that information to them. Particularly on large requests, I always encourage getting that information, because in a large request situation, you may be in a situation where you are collecting a lot of documents, and you may have to email this person several things, or you may have to make arrangements for them to come pick up things. And so it's always great to have contact information in those situations, so that you can work those types of things out. For residents and things like that are going to be maybe frequently at the courthouse, or they live in town, maybe you don't need that information as much, but it is good to have that information under the Open Records Act, just so you can make sure that you give a full and complete response. I would also note that the Open Records Act has specifically prohibits using the open records for commercial purposes. So people can't request open records and then solicit people using the information they received from open records. And so if you suspect that someone may be doing that, you may want to vet that individual to make sure, or to at least confirm that they aren't going to use the information for that. Now, obviously, you don't have the ability to stop them if they say that that's not why they're going to use the information in that way. But you at least want to have them, typically when we will have for KAC, our form actually states that they understand that they are not allowed to use that for solicitation purposes. And because of that, they sign that they will not use it for solicitation purposes, just to protect KAC. And I would encourage all of you as counties to do the same sort of thing. I don't think I have that one in my best practices, but that would be a best practice to actually have a statement in your open records request form that the undersigned understands that by receiving those records, they agree that they will not use those for commercial or solicitation purposes. But again, when looking at this, our chief responsibility is to make records available. And as I said, technology makes this easier. Some records, I would say, should always be available. And when I say always available, you should have the ability to, if somebody were to call you on the phone or walk into your county clerk's office or anything like that, if they are doing that, you should be able to give them the approved meeting minutes from any of your recent meetings. And when I say recent meetings, you don't necessarily have to have those. You don't necessarily have to have the last 10 years of meetings immediately available, but it probably wouldn't hurt to have the last couple of months worth of meeting minutes available immediately. And again, recent commission agendas, recent commission packets, if you do those in your county, those should just be available on a regular, normal basis, to where if anybody comes in and requests that, you can get that to them within minutes, within seconds. If they call on the phone, if they email you, you can respond right back to them with that information, or just have it available on your website to where you can direct them to your county's website where that information is always updated. That information should always be available because it makes it a lot easier on you if you are not constantly having to hunt down the minutes from last week's meeting. That's time consuming, and that's kind of a waste of your time as a staff. That's a waste of your time. And so you don't want to spend a lot of time doing that. If you make those records available all the time, that will make things a lot easier for you. I have a question. It says, can a person refuse to fill out your form? They say that the AG site says that they do not have to fill out the form. I don't know if the AG site says, I haven't looked at it in a little bit, so I don't know if what the AG site says on that. A person can certainly refuse to fill out the form, and if they do refuse to fill out the form, that's fine. You still, even if they don't fill out the form, you still need to comply with their request. I would note, however, if they do refuse to fill out the form, you need to make sure that you have told them and that you have made them aware that they are not allowed to use that information for commercial solicitation purposes. Because again, you're just informing them of their responsibilities and their restrictions under the law as it exists. So you need to make sure and tell them that, and note on the form that you've informed them that they are not allowed to use that for commercial solicitation purposes. Even if they refuse to sign it, that's fine. You can still turn over the records, but you should at least note they refuse to sign the form. A couple of reasons here. And the first is just, you want to make sure that you're having that dialogue with them, that they were informed of that restriction. And then, so you'll remember in the future, I mean, because you may not remember 6 months from now, that particular person, but if you go back and look at the form and it's noted on the form that John Smith refused to sign the form, and now you've got an issue where John Smith is using that information for commercial solicitation purposes. You can go back and say, yeah, I informed John Smith of the requirements. They refused to fill out the form, but you did inform them and you carried out your duty. And so it's important to make sure that you're protecting yourself and protecting the county by at least noting that, even if they don't fill out and sign the form. And this slide kind of touches on that same idea. You don't have to have a formal request. You don't have to have a form or anything like that in order to turn over the record. That's not required. In fact, a lot of open records requests, there isn't any sort of formal request or formal process for it. For larger requests, I always recommend that you do follow a somewhat formal process, simply because, particularly if there are going to be fees involved, you want to make sure that you are, that you have a record of that and that you have a record of exactly what they requested, because it's going to be important if you have a large request that's going to be hundreds or thousands of dollars worth of fees, or that's going to take a lot of staff time, and you know that the fees are going to come with that, or you have a request and you're not sure if you have a record of that. You want to make sure that you have a record of that somewhere, so that if there is confusion later on about what was requested, you can go back to the record. Because one of the things that comes, and I'll talk about this a little bit later, but I think it's important to address it now, is that if there is a complaint to the Attorney General's office, you don't want to be in a situation where it's he said, she said, or your word against theirs. You want to be able to reach back to a record. And like I said, particularly in situations where they are requesting either a large set of records or records that are archived and that you may or may not have anymore, you want to make sure that you are protecting the county and protecting yourself by having some sort of documentation that you can turn over to the Attorney General's office if they are investigating whether or not you complied with the Open Records Act. But you don't have to have a formal request for general records. So if somebody comes in and they ask for the agenda to this week's commission meeting, you don't need to make them fill out the form to get that. You can just hand them the agenda if they come into the office, or you can email it to them if they didn't come into the office. Like, you don't need to have a formal request to do to make those simple kind of responses. But for the larger ones, I encourage everybody to have a form or some sort of documentation, just so you can demonstrate that you have fulfilled that request. And I always encourage, along with that, planning ahead is so important, so very, very important, because planning ahead can save you a lot of headaches. So if you know there is a big issue coming up, plan ahead. I mean, you know the things that everybody in the community is talking about, that there's a lot of buzz or a lot of interest about a particular subject or a particular topic. If you know that sort of thing is coming up in your community, plan ahead, have those electronic files ready, so that when somebody asks for that agenda, if somebody asks for those minutes, if somebody asks for the commission packet, if somebody asks for information that's been turned over that you're going to make public anyway, have that information ready, have it ready electronically, maybe have some printouts ready, so that as people request that information, you can simply turn it over to them, and you don't have to worry about whether or not you have it. You don't have to sort through anything to find it. It will save you a lot of staff time. It will save you a lot of headaches. It will save you a lot of worry if you simply plan ahead. I can't emphasize that enough. Planning ahead will save you a lot of trouble. All right, another thing that is required under the Open Meetings Act, or the Open Records Act, I apologize, is to notify the requester when those records are available. As I said, most of your open records requests you will be able to resolve within a couple of minutes by simply pulling a particular file and handing it over, or emailing it, or what have you. If you are not able to do that, however, it is your responsibility to notify the requester when those records are available. And by law, you must, this is not optional, you must respond to the requester within 3 business days. You must notify the requester if there is a cost, and you need to estimate the cost of the production of those records. Now, when it says you have to respond within 3 business days, that does not mean that you have to respond with the records, that you have to send the records, that you only have 3 days to gather the records. That means that you must respond within 3 business days, and tell the requester, it will take us 2 weeks to gather all of the information that you wanted. There will be a cost of that, and that cost will be $500 for us to pull all the records that you requested. When you are responding to the requester, that is also an opportunity to have an open dialogue to try and clarify, and in some cases narrow the request to get to specifically what that requester is interested in. Oftentimes, requesters will make broad requests because they're not 100% sure what they're really looking for, but that's an opportunity to have that dialogue with that requester and maybe narrow it to where instead of there being 500 potential documents that fall under that request, maybe they're really only interested in 2 or 3 things. But if you don't respond, but if you don't have that dialogue, maybe you never determine that they aren't actually interested in the 500 documents and they really are only interested in the 2 or 3 things. That'll save you a lot of trouble and a lot of headache of pulling records that they're really not interested in. That'll save them a lot of headache for receiving all of this information that they're really not interested in. And it will save cost on both sides because you won't have to send them a bill for $1,000 or $1,500 for the staff time that it takes to pull those records and redact those records and make all of those copies. And they don't have the cost and expense of getting records that really are of no use to them. And so I really encourage, when you are responding to a requester, particularly when it's a potentially large request, that is an opportunity to have a dialogue with that individual and talk about what they're interested in, whether or not the records that you are potentially going to pull are going to be responsive to their request. And it's an opportunity to maybe narrow that request and zero in on what it really is that they're interested in. Because if you can zero in on what they're really interested in, that can save both you and them a lot of headaches, a lot of issues. And that can be done at any time within those 3 business days. But it has to be done within 3 business days that you have that response. And when you're giving that response, you need to tell them what records are available, what records aren't available, the potential costs. And as I'll cover later, if you're denying records, you need to identify why you're denying those records. But we'll get into that later. But you need to use that opportunity when you are responding to them to tell them why those things are, why you're doing those things. All right, I have a question here. It says, can you please talk about standing requests or requests for records that do not yet exist? Certainly, I can talk about that. I know a lot of counties have standing requests from media or from citizens for meeting minutes or things like that. If you have those standing requests and you know that you have a standing request for that, I'm big on processes. I come from a banking background and everything in banking has a process. And I think that's informative here. If you have a process in place for responding to those standing requests, I mean, if you know that somebody's going to, that has requested all of your meeting minutes, maybe start putting those meeting minutes online and just direct them to your website. And as soon as those, and after the meeting where those meeting minutes have been approved, they are immediately added to the website that same day, and they are available to that person that has the standing requests. If, on the other hand, you have a request for something that's maybe a little bit more complex, again, this is an opportunity for a dialogue. If somebody says, I want to know about every transaction that comes through the county clerk's office dealing with dealing with courthouse maintenance, and you have that standing request out there, you may want to have a dialogue about that. Like, do they want to know every time you pay the janitor your janitorial services, or every time you fix the lawnmower that you use to cut the grass in front of the courthouse? Do they want to know about that sort of thing, or do they want to know about something else? And again, this is where you can have those kinds of open dialogues to really figure out what they're driving at. If you are going to have a standing request, I would encourage, again, although it's not required, I would encourage you to get that in writing, because standing requests, if these are going to be long-standing requests where they want everything every time a certain event happens, you want that in writing. And you're going to want that in writing so that you are responding to it with what they're interested in, and also so that there's a record of it, so that if there are any questions in the future, you have that taken care of. Another responsibility is to provide access to records. And again, we've talked about this before, but any person, whether they are a resident of your county or not, they can request access to records, and you have to provide that access because the Kansas Open Records Act is very broad in that respect. Now, it's important to know you can provide the records in whatever form they are kept in. So if a record is digital, if a record is on the computer, you do not have to print it out. You don't have to print it out just because somebody asked for it. You can tell them, we have this record electronically. How would you like me to email it to you? What address would you like me to email it to you? If a record is in print, you don't have to make it a digital record. So if a record is in print and you only have it in print and you do not have it electronically, you don't have to scan it in. You can scan it in, but you don't have to. You only have to provide the records in the form that they are kept in. If it's in an audio format and you only have it in the old technologies of a cassette tape, for whatever reason, if you have a 30-year-old cassette tape that still works for whatever reason, you don't have to put that on a CD or change that into a digital format. If you have video and for some reason you have a VHS, again, you don't have to convert that into a different form. If all you have is VHS because this was recorded in the 90s, you don't have to change it into a different format. You don't have to digitize it or get it in an up-to-date format. If you only have it in that form, that's the form that you provided it. Now, I will note that if you have it in multiple forms, the requester can ask for it in the form that they prefer, if you have it in that form. But you don't have to convert something from PDF to Word just because somebody requested it. If you have it only in PDF, that's what you provided it. You also have the responsibility of making copies of records. And again, because you are only required to provide information in the form that you have it in, that doesn't necessarily mean that you have to print out hundreds or thousands of pages of copies. You can send them a PDF of those documents. You don't have to print things out. When it says make copies, you just are making a copy. If that's a digital copy, if that's a physical copy, it's all just a copy. Now, if you do make copies, you can charge for actual expenses. And this is where we need to make sure that we are very precise with things, because you can charge for actual expenses, not for potential expenses. You can only charge for actuals. So you will give them an estimate when you respond to them initially and tell them, I think this will cost about X number of dollars. But after you have performed the work, you need to charge them for only the actual expenses. You cannot charge them for more than that. You can only charge them for the actuals, for the actual staff time it took to make copies. So if you thought it was going to take an hour to make all the copies and you got it done in 40 minutes, you can only charge them for 40 minutes of staff time for making copies. If you thought it was going to take 5 hours to go through all of the documents and redact them and it only took 3, then again, you can only charge them for that staff time for the 3 hours. You can't charge them for the 5-hour estimate, only the 3 hours. If you thought they were, if they said originally that they wanted all the information in paper and you were going to print it out for them and charge them for that, but then they changed their mind, and because you have it digitally, you could provide it to them in digital form, you cannot charge them for the cost of printing because you didn't print anything out. You can only charge for the actual expenses. And we encourage you to always include those in your estimate. Now, I will note here that one of the things that we have to be aware of and be careful of is that there's a lot of belief among some people that estimates of costs are sometimes inflated in order to discourage those requests. So try to be as accurate as possible, obviously, in your request. And I think everybody does that, tries to be as accurate as possible, but also be prepared to articulate why those costs are what they are, if you have questions, because sometimes, again, in having that dialogue, just being able to explain that may, again, solve you a lot of headaches and eliminate a lot of answers or eliminate a lot of questions that you come upon. Have a question: is the staff time calculated by the lowest paid employee wage? The staff time should be calculated by the person that the lowest paid person that can do that particular task, not necessarily the lowest paid employee wage. So for example, if you are doing copies, you should not be charging for your county counselor to make those copies. It should be one of the administrative individuals in the department, or somebody that, so anyone that can perform that task. However, if you need to have redactions done, that's not going to be done by an administrative assistant. That's going to be done by your county counselor. And so you can charge for your county counselor's time because your county counselor is the one that is able to perform that work. And again, this shouldn't be something that you're doing to drive up the estimate in an effort to discourage people from making requests. It's just a reflection of the actual costs, whatever that might be. So it really should be based on who can actually perform the work that is being requested to be done. Yeah. You also need to collect the fees when they are applicable. Again, as we have talked about, the fees must be based on actual costs. Cannot stress that enough. Fees have to be based on actual costs. This is one of the areas where counties can get into trouble if they are using estimates rather than actual costs. You could get into some trouble with the Attorney General's office if you are not focusing on actual costs. So let's talk about the anatomy of an open records request. So are you a public agency? You're the county. So of course, the answer is always yes. If you receive an open records request as the county, you're a public agency. There's no getting around that. Every record that you have is potentially subject to the Open Records Act, depending on exceptions. So is the record one that is made, maintained, or kept by the county? As we ask these questions, drafts and notes are not open records, but if you are in possession of a record and it's in its final form, that is a record that's made, maintained, or kept by the county, and therefore would be subject to the Open Records Act. Is the record public under the law? Now, this is an important thing, because this is where we start talking about exemptions and exceptions, because there are some records that are closed. Sync cases, for example, those records are maintained by the county, but those records are closed under the law. Other things would be public. Does the record or any portion of that record fall under an exception to the Open Records Act? And here I encourage you to get your county counselor involved. It's better to get your county counselor involved early on as opposed to waiting until there's confusion. Remember, you only have that 3-day window when you're going to give your response to the requester of whether or not you have the records, how long it will take to produce them, all of those things. So you need to get your county counselor involved up front if you have a request, particularly if it's a complicated request. And this process really focuses more on the complicated requests than it does on the simple requests. If somebody comes in and asks you for the county commission agenda for this week, you don't need to go through all of these steps. You can just hand over the agenda. If somebody asks for the last 5 years of county commission agendas, you probably need to start estimating some of the costs that are associated with that as you get ready to turn those records over. Not because there's an exception that would prevent you from turning that over, but because you may have some cost involved if you don't have a quick way of producing those records. It may take some staff time for you to produce those records. And don't be afraid to look at the open records law as you're working through this. Don't be afraid to look it up to see if an exception applies. Have those conversations internally. Because again, you don't want to turn over anything that you shouldn't be turning over, but you also don't want to deny a request that you should be filling. You want to turn over everything that should be turned over and protect everything that should be protected. All right. Is the disclosure of the record required? And when we think about that, again, there are some records that are closed automatically. There are other records that don't fall under any exception. If that's the case, disclose the record. If you have the option of whether or not to disclose the record, in other words, you are not legally required to close those records under the law, you can decide whether or not you're going to disclose the record. I would encourage everyone to always have a policy on how you're going to handle optional disclosure of records. You don't want departments doing things a lot of different ways because that causes confusion, and confusion is always something that leads to frustration. Because if I get something one way over here, and then I come to this different department in the county and they are handling things differently, I'm going to be frustrated because I'm going to say, I was just down the hall and they gave me this information. Why aren't you giving me this similar information? So again, you want to have a policy on how you handle optional disclosure, and you want to be as consistent as possible when you're doing that. If the request is denied, always, it is required under law, and that is why I say always. If the request is denied, always, 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 always provide a written response. In that written response, you need to include the reason why you are denying the record. In addition to that, you need to cite the specific statutory exception that either allows the record to be closed or the exception that you are utilizing to deny the record, either because it's closed or because there is an exception under the Open Records Act. Always include those citations, include the statutes that you are relying on, because it's important that you be able to demonstrate, and this is also helpful if there is a complaint in the future, you can make sure that you can show that to the Attorney General's office if there is any sort of complaint that, yes, we did provide this information to them. we denied it because of this particular reason, citing this statute, because these are the records that they requested, or we redacted this information because it would have gotten into these things and we redacted it under this exception. You want to make sure that that is in your response so that it is clear what rationale you used in order to deny those records. All right. So now we are on to what in a lot of ways is my favorite portion of every program, and that is best practices. And I like the best practices because it gives you something that you can take away from this program today and apply it this afternoon if you need to. So I always enjoy best practices because it gives you kind of those little tips and tricks that you can use maybe even today as you are working in your office. So first, know what records you have. It's critically important that you know what records you have as you are working on open records requests. And it's critical that you know what records you have because when requests come in, you need to be at least somewhat familiar with whether or not you can respond to that request. It's also important because it helps speed up your response to those requests. Remember, even for complex requests, you only have 3 business days in which to respond to the requester and tell them how much time it's going to take you to produce those records. So if you don't know at all what records you have, it's going to take you a lot of time just to figure out, do we even have this on hand? Do we have this? Do we know where it is? You may have to pour staff time just into figuring that out if you are not somewhat aware of what records you have. So a best practice is to just be aware of the records that you have. And not only being aware of what records you have, but know what form you have those records in. If somebody's asking you for something in digital form, know whether or not you have that in digital form, or if you only have paper copies of that particular record. Know if you have recordings of certain things, if they are audio files, or if you have video files of certain things. Know all of that. Know where things are stored so that you can have a quicker response. So know what form and kind of where those things are so that you can just speed up your response. And so you're aware of how you can respond to different individuals as they make those requests. Keep regularly requested records easily accessible. As I said, some records should always be available where you can just pull that record immediately with no problem, with no trouble. In 5 seconds, you can grab that and attach it to an email or hand it across a desk or whatever it may be. But keep those regularly requested records. And again, some of those include things like meeting minutes, agendas, board packets. Keep that kind of thing regularly and easily available, just because it will save you so much trouble, so much time. It'll save you a lot of headaches if you have those things that are frequently requested, easily accessible. And this is a great place to use technology as well. Use your website to your benefit here, because that may help you cut down on the amount of staff time and staff attention that is taken to respond to open records requests. Know your exceptions. And this is important because, again, as I said before, you want to turn over every record you are required to turn over. But you also want to make sure that you are not turning over anything that you should not be turning over. We want to make sure that we are protecting privacy as much as possible, but we also want to make sure that we're being transparent and turning over every single record that we're required to turn over while protecting those records that should not be turned over. So be familiar with your exceptions. And this goes back to knowing the records you have. As you know the records you have, you should also know what exceptions apply to those specific records. You should know what exceptions might apply, what exceptions could apply, what information may need to be redacted out of certain documents. You should be somewhat familiar with that by knowing your exceptions and also knowing the records that you have in your particular department. Have a fee schedule. And this is so very important. Have a fee schedule, because you should be able to turn over the records. You should have within your county a fee schedule that tells people what you charge for copies, what the salary ranges are for staff time. You should have all of that available so that people know, or can at least kind of estimate for themselves, what those costs might be if they request certain records. And then, of course, be consistent. I can't emphasize this enough, and this is probably the most important best practice. Just be consistent as you are dealing with records requests. As I said, there is nothing that will get members of the public more frustrated than inconsistency, than walking from the treasurer's office to the clerk's office and having two completely different experiences on records requests because one office does it this way and the other office does it that way. So try to be consistent within your county. If you're not sure how requests should be handled, it's okay to have a dialogue within your county about how you're going to handle records and how things should be handled. Are you going to route all of those requests through one particular office so you can maintain consistency that way? Or are you going to have each individual office handle their requests, but they're going to all handle it under a certain policy that everyone has agreed to? Again, consistency will eliminate a lot of headaches if you are consistent with how you are handling those types of requests. And of course, if you have questions, if you're encountering problems, if you have any sort of issues that you're not sure about, by all means, feel free to get in contact with me. My contact information is there on the page now. But if you have other questions, obviously, feel free to ask those now if you'd like to, or feel free to reach out and get in touch with me later on, and I'd be happy to have a conversation with you. I know several of you I've talked to here over the last couple of weeks about different issues that have come up for you, and feel free to always call me. But if there are any questions right now, feel free to ask those. Oh, looks like we do have a question. Are you able to get copies of these slides and those from the KOMA webinar? The answer is yes. Those slides, I don't know exactly when Kim will send those out, but those slides will be available to you, both for KOMA and for today's KORA presentation. I've got another question. Providing records does not include doing research, correct? That is correct. Research is not, it is included in what I call the business exceptions. And let's see if I can get back to that slide. Oh, I skipped it. Yeah. Notes, preliminary drafts, or research. And that's KSA 45-2221A20. So yeah, research is not included in records under the statute. Any other questions? Oh, we've got another question. Oh, I certainly appreciate that. And I appreciate everybody getting on today for the presentation. And again, if anybody else has questions, I'd be happy to answer those. If you want to send me questions later on, feel free to send me any questions that you may have. Otherwise, we are at the 11 o'clock hour, and so I don't want to hold anybody. If there are not any other questions, I don't want to hold anybody past the 11 o'clock hour. But if you do have questions, feel free to ask those. Otherwise, thank you for attending and have a great rest of your week, everyone.